Good afternoon, and welcome to the session on copyright in the age of accelerated science and AI. I'm Jennifer Schenker, founder and editor-in-chief of The Innovator, a global publication about innovation. I'm going to start by framing the discussion with an example. Earlier this month, DeepMind, it's a British-American AI research lab owned by Google, and German drug maker BioNTech separately announced that they will be launching AI lab assistants to help advance science. At the same time, BioNTech's London-based AI subsidiary, InstaDeep, presented AI models that could help the drug maker identify or discover new targets to tackle cancers. The announcements underscore how AI could accelerate science discoveries, but also raise a whole host of thorny questions. If human scientists collaborating with AI lab assistants make an important discovery, say, find a cure for some lethal disease, who should receive the patent? The person or company who developed the AI assistant, the scientist who instructed and collaborated with the AI assistant, the AI assistant itself, or a combination of all three? And if such a discovery can be made in a day or even minutes at a fraction of the current cost, do we need to rethink the whole economic model underlying drug discovery and prescription drug pricing, and ensure that the patent system grants early and fair access to people around the globe? As AI accelerates scientific progress and patent creation, the clash between the human right to benefit from scientific progress and its application, the human right to science, and the right for innovators to protect their inventions is intensifying. How can we design future protection models that balance innovation, access, and fairness in a rapidly evolving technological landscape? That's the main question we're going to try to tackle during this panel today. So it's my great pleasure to welcome, to my immediate left, Ken Natsume, the Assistant Director General of the World Intellectual Property Organization. Next to him, James Donovan, who is OpenAI's Head of Science Policy and Partnerships. And then we have Tony Taubman, the former Director, Intellectual Property, Government Procurement, and Competition Division of the World Trade Organization. And joining us virtually, we have Christine Allan de Lavenne. She is founder and head partner of Side Law Office, and she is an intellectual property lawyer and human rights and innovation expert. And she could not be with us in person, but we're very happy that she could join virtually. So Christine, I am going to start with you. Please help us to frame this discussion, because many people are familiar with patent law, but maybe not so familiar with this human right to science. So can you please reference the precise articles from the Universal Declaration on Human Rights and explain exactly what the right to science is?
Thank you, Jennifer, and hello to all of you from far away here in Riga. I want to take just a minute to express my gratitude to GESDA and particularly to Monica Ploza for giving me this opportunity to talk about this topic with these amazing panelists. I am very excited to hear your feedback. It means a lot to me. I'm also very bummed to not be part of the interesting talks at coffee and dinner, but my doors and my emails are always open, so reach out to me anytime with questions. So the right to science, as you said, Jennifer, is a human rights which is described in Article 27 of the Universal Declaration and 15 of the Covenant on Economic, Social, and Cultural Rights. Both of these provisions seek to allow all human beings to freely participate in science, for one thing, and benefit from scientific progress and its application. Also, both of these instruments carry an additional paragraph that indicates that the above rights need to be balanced with another right, which is the right for scientific creators and innovators to benefit from the protection of the moral and material interests resulting from their work. This really shows that from the get-go, these two sets of rights have been perceived as interacting, and that the proper balance in between IP and the right to science is the goal to reach, with the constant need to fine-tune it to adjust to new realities. This balanced drafting of these instruments also clearly indicates that the right to science per se could never happen if scientific creation were not protected, if the innovation path was not valued, and if scientific progress was not incentivized. Indeed, what would the world look like if someone could just sit and wait for another to invest and put all the hard work and all the money to reach a great innovation and could just from there pick on from it, draw the benefits without having to spend a dime or a sweat? Scientific progress and innovation would not happen if IP did not exist. It is undoubtable. Sadly, for decades and widespread, including within the UN and international institutions, the right to science and IP have been perceived as straight up enemies. And to some extent, it has been claimed that the right to science could not be respected if we did not get rid of the big bad IP. So, of course, if you look at it from a micro perspective, IP grants an exclusive monopoly of use on a part of scientific progress to one person or group of person. So it does look straight up as a way of locking up the right to science. But there is much more to this in common and much more to achieve together. And I will happily elaborate on this a little later if you wish.
Thank you, Christine. And so, Tony, let me turn to you. So, Christine rightly pointed out that, yes, there's always been this kind of tension between right to science and IP law. In your mind, is the introduction of AI and other new technologies accelerating this? And if so, why?
Well, certainly, I'd agree with Christine that we do need to look at these two sets of rights in a holistic way to see how they work together. After all, the right to scientific progress includes the right to benefit from its application, and that's very much, the delivery end of innovation, if you like, that we need to consider. There, I think the IP system has to be understood not at the level of human rights as such, but as a practical tool, as a utilitarian tool. That means that when a new wave of transformative technology hits us, we need to recalibrate that tool. That's very clear. That recalibration can be quite fundamental, but it's an incredibly important process. If you look at the ancient history of IP, the creation of photography is actually an interesting analogue, because the debate over a century and a half ago was, well, look, that's not creative. Apologies to the photographer. That's not creative. All you're doing is pointing a machine. So the machine you're just running a machine, which is exactly the argument about AI innovation. What happened was a necessarily contentious process that was part empirical, but look, what the hell is going on? What is the impact of this technology? And it's a technology that evolves, so that in itself is a moving target. Secondly, the contentious process. Let's hash it out. Let's go back to the basics. I think this is critical. The basic idea that yes, you've delivered new knowledge, you've delivered new creative work that we can all potentially benefit from. but you don't have the right to lock it up absolutely. No IP right is absolute. There are critically important balancing measures that do need to be adapted and applied so that something like the World Wide Web that was invented right here can actually function. If every syllable was locked up by absolutely exclusive rights, we wouldn't have this wonderful torrent of knowledge that was generated here with the creation of the World Wide Web. So that contentious process is important. Above all, it should be an open, inclusive, diverse process, which is a more abstract way of saying it shouldn't just be left to the courts, which is what we're seeing at the moment. That is the ultimate, contentious hashing out of these issues. But I think it's more, all due respect to the court system, there's far bigger issues at play here. Going back to an absolute basic question of what is it to invent? Fundamental question that's the pivot of all patent law or IP. What is an original work in the copyright world? Fundamental questions. It's bouncing at the moment between legislatures who don't want to touch it and courts that are forced to touch it. And meanwhile, and this might be the right segue, there's thankfully scope opening up for an international, truly international conversation about how to rebalance, how to recalibrate, how to go back to basics and rethink what this new wave of technological disruption can and should lead to.
In conversations before this panel, you and I talked about, it's not even just a question of, well, is the work derivative, but also who or what can file for a patent. So far, the courts have refused to recognize AI as, having the right. Can you talk a little bit about that case and where you think that might go?
Yeah, well, so a slightly geeky patent law twist on that. It's the question of not who gets the patent so much as who's the inventor, and all patent rights flow from that act of invention. But typically, a company, an institution, or somebody financing you might be the owner of the patent. But the question that's come up in this classic case, the Taylor case, that's been litigated around the world is, can a machine be an inventor? And that goes back to some really basic, really interesting questions about even personhood. Because the rule is that in most countries that an inventor is defined as a person, a human person. So the issue is, what if an incredibly clever and inventive machine, not a biological person, but does something that is exactly the same or has the same inventiveness as a human inventor? Should that be the same kind of inventive step, the same kind of progress that a human inventor would get? If not, why not? And it does tangle between literally the distinctness of human beings and the very clever android that's much more inventive than I am. So that's the critical question, and we are both in terms of international law and domestic law on intellectual property, we are very much tied to the idea that a human being must be the source of the creativity in the copyright world, must be the source of inventiveness when it comes to technology.
So, Ken, let me turn to you now. Sure. How is the World Intellectual Property Organization dealing with these kind of questions?
Thank you very much, Jennifer. So that's an excellent question, and thank you very much, Tony, for the elaboration about the inventorship issue, which has been on a discussion for a while. And that's why WIPO, our organization, is taking some initiatives. And let me highlight 3 elements: discuss, provide, and support. The first, discuss. At WIPO, we have the venue to discuss or debate or even argue all these kind of things, including the AI can be an innovator or inventor. And this is not only for the WIPO's member states, but it's open to everybody, public, academia, even individuals, students, youth. So we have been organizing this kind of open dialogue twice a year so that everybody can get together. At least we can recognize what's the commonality, what's the differences, so that if we can have some kind of convergence, then we can think something in the future. But just to be frank with you, we are not there yet, but we continue our discussion, and already next month, November 6 and 5, we will have another one to focus on the issue of the output of the generative AI, because that we are talking about if the output of the generative AI, such kind of music, photograph, or drawings, can it be copyrightable or not? And even in the multiple jurisdictions, there are differences of the views. So that's why where we are.
So right now, there is no consensus between countries on that question, correct?
Right.
So some countries are leaning towards, saying yes, a machine can create an artwork and it can be patented, and others are saying no. So how will we, just to go back to what you said, Tony, how are we going to get some kind of international consensus? Because, in addition to some of these newer questions, the whole digital age has introduced a number of other issues, like does it make sense to have IP law based on national borders in a digital borderless world? And so how are we going to address some of those questions going forward? Ken,
that's a very valid and interesting question, but also that's a very difficult question to answer, because at the international level, if there is no consensus or no convergence of the views, it's very, very difficult to form some common rule or common regulation at the international level. And as already mentioned, in the copyright case, there are completely different results from the different jurisdictions. One says, yes, the output can be copyrightable, because in order to get the final product, the creator or operator have to prompt many times, 100 times, 200 times. So that's a kind of a human creativity work. But the other view is very much different. Yes, you can input many, many prompts, but the output is obtained from kind of black box, which is called AI, generative AI. So that process is not obvious or not clear to us human being, so we cannot consider it as a human being created artwork. So that's a very valid question, but it's a very tough question to see some commonality, because as you can see, it's completely opposite.
So, James, this seems like a good time for me to go to you. So, you're representing OpenAI, which is, a major player in developing generative AI. It's the company behind ChatGPT. There are concerns that about access around AI. That maybe only the AI companies or huge wealthy companies like pharmaceutical companies would have access to this infrastructure, leaving smaller labs and scientists who don't have access to it, at a disadvantage. You have a really interesting perspective, because despite working for OpenAI, which is soon to become a commercial company, you have a dual degree in biology and economics. And before working for OpenAI, you worked for an organization whose, raison d'etre was to study how can we open access to science. So give us your perspective on, what are some of the new models that might evolve? How are you looking at this topic?
No, thank you. And it's a pleasure to be here, so I feel very honored to be speaking to you all. I'm not a lawyer, so as possible, I'll trample all over the nuances of intellectual property. Apologies in advance if I do. But I do look at this from first principles, and I think we're probably all aligned with the idea that what we want to do is get to a point in which science is being catalyzed faster in a safe and equitable way. And that is going to be critically important for all of humanity in order to address a number of challenges that we're facing. And I see AI as a means to that end, is really finding ways to accelerate the time from scientific discovery to actually being beneficial to the wider world. I don't think you can uncouple things like intellectual property, therefore, from the actual act of doing science and the incentives that are around that. And what I'd like to see is a diversification of the different ways in which science is supported, funded, and done to reflect the fact that actually science isn't this monolithic entity. There's lots of different approaches, different domains, different elements that lead to different outcomes, whether it's funding individuals because you're looking for a conceptual breakthrough, more, and this is what I would really like to see in the world, more kind of engineering science, where it's building the tools you need to do science, and the different ways that could be funded, I think can range from the government-style grants you get today to things like focused research organizations. We see that as a core model, the ARC Institute and the various FAST grants they do, effectively ways of saying there are different ways of approaching science, let's fund them differently. And then we can attach different notions of IP to that. I'd like to see a world in which the idea of IP was much more granular, so that you could play around with it, you could fine-tune it, you could think about ways to resolve it. Even when we come to these sort of philosophical debates around, could an AI model be granted agency such that it got its own patents? Even in that outcome, and that's a long way to go, I think we'd still be saying, well, we want to incentivize different people in that process, and therefore we need the means to be able to do that. The last thing I'll say is just, as we catalyze science, and I hope we do as OpenAI as well as everyone else in the space, it is possible that as you automate things, the risk-reward balance starts to change. Originally, a lot of this thinking around IP had this idea, well, scientists are taking a huge risk, or companies, or research institutions. It takes a long time, a lot of expertise. If that risk does start to change, then clearly the reward should change too. And we need to think about how that balance continues to operate. And that might need very kind of variable approaches depending on what problems you're solving, what part of science you're going after.
And then just going back to the role of AI infrastructure for a minute. So, if AI is playing a role in the discovery, regardless of whether it's regarded in the same way as a human, but if AI is playing a role, then, do you believe that the provider of the AI should benefit from the discovery?
So I think if the practical question is there a world in which we arrive at a scientific breakthrough that could not have been done except for the help of an AI model, then yes, I think that's quite a practical short-term thing that will happen. And to a degree, the Nobel Prizes going to Demis and Steve Hinton only today and yesterday kind of show the speed at which that is happening. But my interest there is more saying, well, that's just recognition that scientific infrastructure is very important to making scientific breakthroughs. There's lots of types of scientific infrastructure, from small things like microscopes to particle accelerators, and that we have to recognize that science is becoming increasingly reliant on this ecosystem approach versus the sort of lone genius in the lab. AI will be one of those pieces of infrastructure potentially, and in the same way as I would see a world in which governments can be front-footed about public infrastructure and saying, well, if you want to use data from CERN or you want to use the capabilities of CERN, we need to have a structure in place that benefits the public. The same thing could be true for AI models, which is to say smaller companies could be using or leveraging OpenAI's models under different types of licensing agreements. But again, I'd like to see that in a framework that was sort of dynamic to the need, not just a top-down, here's how we've always done IP, it should reflect this as closely as possible, that there is a place for that too.
So in that model that you just mentioned, AI would actually be enlarging access to scientists rather than reducing it. So that's an interesting thought. And now I want to go back to you, Christine, because, James is talking about, introducing whole new ways of thinking and, about IP law. So do you think that this will mean that IP is dead?
Thank you, Jennifer. I love provocative questions. I also like very simple answers, and I will tell you straight up, no. IP isn't dead, and there is absolutely no reason to kill it. Quite the contrary. What needs to be done on another hand, is to realign some planets in between the scientific and IP communities to refocus on the common goals and mutual benefits. And the second thing that needs to be done is to identify the IP tools that can be used to renew the IP right to science balance that we need or want to achieve. On the common goals, my eminent colleagues have addressed the key concepts of inventorship and authorship, and that is wonderful, to which I'd like to add the criteria of utility in patent law. Utility is a principle that restricts IP protection to innovations that demonstrate an industrial application, meaning that if an invention is not able to be industrialized to benefit to the larger number, it is not protected by IP or not worth protection. This clearly resonates with the goals of the right to science to allow the most to benefit from scientific progress and their applications. Now, on the tools, in an article that hopefully I will be finalizing soon with my colleagues from Professor Helle Portstam from Copenhagen University and Sebastian Taubman from Oxford University, I like to identify these tools as the 3 X's for exclusions, exception, and expiration. Exclusions is the dial that allows to determine what is and is not protected by IP. This dial is precisely the one we need to use to define what scientific benefits stand outside the realm of IP and are most accessible to most, and the others. Exception is the dial that allows for IP protection barriers to be taken down in instances that are mostly driven by the right to science, such as health crises. And this dial allows for a portion of scientific progress to be accessible to the most through mechanisms like generic waivers and compulsory licenses. And expiration is the dial that allows to define how long IP protection lasts. And to this point, I think Anthony was pointing out to this. This dial is really the very backbone of IP. The temporary character of patent is historically the only reason why this legal monopoly has survived. Now, how can we use these 3 dials to adjust to today's reality? In the exclusion field, there has been this guiding principle all along in IP that IP protects mankind, what mankind creates, as opposed to what mankind discovers or reveals. Laws of nature, laws of physics are not appropriable. A similar approach could remain within the area of AI, where all the work to create the software, the models, the tools would be patentable. All the work and creation done by the humans, if we stay on those lines, or to be further defined, that would be done with the outputs of the models, could also be protectable. But if produced by the machine itself, it would be outside the realm of IP. Now, exceptions, compulsory licenses are a very debatable tool, but it has shown some efficiency throughout the years. It definitely needs some adjustments. 2 of them, or the most significant one in my mind, are the need to adjust to the global world and break the boundaries of national applications. The second one is to have compulsory licenses reach beyond the only IP component or patent component, of the innovations that we have nowadays, and to reach out to other components such as trade secrets and copyrights to address the reality of what an innovation is today. Now, expiration, I believe that the average 20-year marker needs to be revisited in an accelerated world of innovation. For reference, and we were going back to the history of patents, the very first patent ever granted in the 3rd century of Ancient Greece was for 1 year. Later on in the Venice Republic, it was 3 years. Maybe we need to work the clock backwards. And some bad practices like improvement patents or the Prindle effect, for those who are familiar with this, which in essence allows to renew the patents forever and have a protection forever, those are also aspects that need to be better tackled by the IP of the future.
Thank you, Christine. So, Tony, if I just go back to you real quickly, I'd like you to react to what Christine said. Do you believe that we can just turn the dials, of these three levers, and that will suffice, or do you see this as an opportunity to really think out of the box and maybe redesign, core elements of the system?
I'd be tempted to put the box aside altogether and sort of shift metaphors. I think you can do both at the same time, if that's not too quantum mechanical. I mean, we can have waves and particles at the same time. Why I say that is because dealing with those dials, you're getting into quite fundamental questions of principle, core principles. And I don't think in this whole debate we will get away from those principles. Just what new contribution of knowledge, technology, creativity merits some kind of recognition. And another dial is that of recognition or moral rights, or just that idea of attribution, which is part of the human rights framework. There's another dial which is more the application or the management of what you have. There's an old song, it ain't what you got, it's how you use it. And we really need to look at strengthening incentives or even stronger leveraging more open licensing structures. So you can have the same traditional patent portfolio brutally, exclusively, aggressively protected, or the same portfolio very widely and cooperatively, collaboratively licensed. It's the same thing, the same technical right, but it's deployed in such different ways. The way not to do it, and this would have got me sacked, is what happened with computer programs. In the 1980s, there was a very spirited, very helpful, thoughtful debate about what kind of IP is needed to protect computer programs. Do we at least think outside the box? Do we deal with Christine's complicated constructive dial system, or do we come up with something completely different? There was a lot of debate about sui generis systems for computer programs. What we ended up with was a series of deals saying, that's too hard, let's pretend that a computer program is the same thing as a novel. And literally that's the phrase. Computer programs will be protected as literary works, with protection running for the life of the author plus 70 years, which doesn't seem to, I wish Bill Gates a long life, but the idea that MS-DOS would still be in copyright 70 years after, so that to me is a good example of how an opportunity to think outside the box, or at least to really push those dials to the limit, push the envelope, that opportunity was lost, and let's not see that happen with the next wave of technological disruption.
Thank you. So we're almost out of time, so I'm going to ask quickly, since GESDA is all about anticipatory, what do each of you think IP should look like 25 years from now, especially in terms of emerging technologies like quantum and vital sectors such as healthcare and food security? Who wants to go first? Ken?
Maybe, thank you, Jennifer, because I'm sitting next to you, so probably let me try to address it. In 25 years, of course, I don't have a crystal ball, but what I would like to see is the intellectual property is utilized not only by the, let's say, tech giants, but also by all different areas of the globe, including, let's say, developing countries, third world, and even youth. So this is what I'm hoping. Thank you.
Okay, thank you. James.
Thank you for going first, Ken. That's very brave. I think from my side, what I'd like to see is both structural and specific. I would really like to see a world in which we had much more clarity about what we consider to be basic or foundational research that must be done in the public domain, and applied research, which I think at the moment is a very blurred line, and AI will further blur that. And then two, I'd like to see a system in which each of the incentives were much more formalized and could be traded in, traded out, and slid up and down in terms of how important that particular incentive is to that type of research, and that ability to recombine things against specific types of research was just normal and open to being done.
Tony.
I was hoping we'd run out of time.
It's okay.
I guess, I would build on what others have said and really say that there's a risk of, there's two broad trajectories. One is fragmentation, monopolization, the development of dominant spheres, or we have a more open, supple structure, and behind that is a different conceptions of what IP is about. Is it a fundamental asset that I protect for its own sake? And there's by the way, a national security dimension here too. We haven't had time to touch on, but that's a really significant driving consideration at the moment. Or do we take the lead of Tim Berners-Lee here in CERN and the development of World Wide Web and see the possibilities for greater diffusion of knowledge, a more collaborative platform, and IP is part of that. Because one thing that IP can do and should do is it is the way of constructing technology partnerships. It's the architecture of collaboration. It's the way of getting financing and resources into the directions of not only the scientific progress, but the application part, the development, the diffusion part that's so important. And IP can be that mechanism for diffusion, for collaboration. But we have to make it work like that.
Thank you. Christine.
Well, I think a lot has been said already, but I would definitely wish for IP to extend its boundaries outside of law and economics and be a lot more inclusive in how it is elaborated, constructed, and evolved with the beneficiaries as much as the IP innovators or makers. Much more cooperation would be helpful and more flexibility on addressing the moves of technology in the future, for sure.
Thank you. And so now, last question, lightning round, because we are already over time, but this is a call to action. What is the one thing that each of you thinks should be done short term to ensure that current IP law does more to take into account the human right to science? I'm going to start with you.
Develop, promote, leverage, encourage more transparent and more open licensing and technology diffusion structures.
Okay, James.
Really building off that, I'd love to see a proactive version of the GESDA radar for what we want to invest in science to make things happen and to attach the way we think about IP incentivization to that roadmap.
Okay, thank you. Ken?
Outreach to the colleagues who are not familiar with intellectual property more. Yeah.
Christine?
I will reiterate what Ken just said, and I will also add that I believe reducing the duration of protection will be key in the near future.
Thank you. So our panelists have generously agreed to kind of stick around. So while the session is now at an end, you can come up and talk to them, ask your questions. And I'd like to ask you all to please give a nice round of applause for our panel. Thank you very much.